Welcome to The Explainer. Have you ever been wronged by someone? I mean, really wronged, and just wondered, is there actually anything I can do about this legally? Well, it turns out there's a whole area of law for that, and today we're diving deep into what it's called the law of torts.
All right, so let's jump right in. The word itself, tort, actually comes from the Latin word tortum. And what does that mean? It means to twist. Kind of cool, right? So right from the get-go, you can think of tort law as dealing with conduct that's, well, twisted. It's not straight, it's not lawful.
But here's the thing, right? Not every single twisted act is something you can sue over. I mean, that would be chaos. So this brings us to the big question, the one we're going to unpack today. When exactly does that wrongful, twisted conduct cross a line and become a legal wrong, an actual tort?
So to answer that, we've got to get a really clear definition down first. What is a tort exactly? Okay, so here it is, the textbook definition. A tort is a civil wrong, which is different from a contract issue, and the remedy is something called unliquidated damages. Now that sounds super technical, I know, but don't worry. All unliquidated damages means is that there's no set price tag on the harm. A court has to figure out what the compensation should be based on what actually happened.
And this is a really important distinction. The main goal here isn't about punishment. It's not like criminal law where someone might go to jail. Nope. The whole point of tort law is to compensate the victim. It's all about trying to make that person whole again, to put them back in the position they were in before the whole mess started.
Okay, so how do we get from a simple wrong to a full-blown tort that can stand up in court? Well, it's not enough to just point a finger. You have to prove three specific things, three essential ingredients, you could say.
The way I like to think about it is like a three-legged stool. First, you need a wrongful act. Second, you got to show that act caused legal damage. And trust me, that's a key distinction we're going to get into. And third, there has to be a legal remedy available. If you're missing even one of those legs, your whole case just tips right over.
So, that first leg of the stool, the wrongful act, this is pretty straightforward. It has to be an actual act. Or, and this is just as important, it could be a failure to act when you were legally supposed to. You can't sue someone for just having bad thoughts, right? It has to be something they did or didn't do.
Now for the second leg, legal damage. And listen up, because this is probably the most misunderstood part of torts. The plaintiff has to show they suffered a violation of a legal right. This is a huge deal because it's not always the same thing as suffering, say, a financial loss. It's about a violation of what the law protects.
And there are these two awesome old Latin phrases that just nail this concept. First, you have injuria sine damnum, which means injury without damage. Think of it this way. Someone violates your legal right, say they wrongfully detain you, but you don't actually lose any money. Guess what? That's still a tort. Now flip that. Damnum sine injuria means damage without injury. This is where you actually suffer a loss. Maybe a new competitor opens up in your business tanks, but no legal right of yours was violated. As tough as that is, it's not a tort.
And if you look at law exams and what they really focus on, it's this stuff right here. Understanding these basic building blocks, the nature and elements of a tort, is absolutely fundamental. It's the foundation for everything else in this field. So this is the part you really want to lock in.
Okay, so that brings us to the third and final leg of our stool, the legal remedy. And just like before, there's a classic Latin maxim that sums it all up beautifully.
It's ubi jus, ibi remedium. It means where there's a right, there is a remedy. And this is such a powerful idea. It basically says that it's pointless for the law to give you a right if there's no way for you to enforce it. This principle is why tort law is so alive and constantly changing. It means the categories of torts are never a closed book. As society changes, the law can recognize new wrongs.
All right, so we've got a pretty good handle on what a tort is. But sometimes the best way to understand something is to figure out what it isn't. So let's draw some lines in the sand.
First up, tort versus crime. People get these mixed up all the time, but the key difference is who was wronged. A tort is a private wrong. It's between individuals, and the whole point is to get compensation for the victim. A crime, that's a public wrong. It's seen as a wrong against the entire state, against society itself, and that's why the goal is punishment, not just compensation.
Okay, so what about torts versus contracts? Here, it all comes down to where the duty or the obligation comes from. In a contract, you and another person agree to a duty. You choose it. But in tort law, the duty is just there. It's fixed by the law. Like, you have a duty not to drive negligently. You didn't sign a contract for that. The law just says so. And you owe that duty to everybody.
All right, we've covered a lot of ground. We know what a tort is, we know its three key parts. But there's one more layer to this, and it's a big one. Let's talk about the mind. Does what was going on in the wrongdoer's head, does their mental state, actually matter?
Well, the law is super specific about this. It draws a bright line between intention and motive. Your intention is what you wanted to happen. Your motive is why you wanted it to happen. In tort law, your intention can be absolutely crucial, but your motive? Most of the time, the law doesn't care. Having a good reason for doing a bad thing doesn't get you off the hook. And having a bad motive doesn't magically make a legal act illegal.
And this gets even trickier with a word like malice, because in law, it has two totally different meanings. There's malice in law, which is just a fancy legal fiction. It basically just means you did something wrongful on purpose without a good excuse. Then there's malice in fact, which is what you and I would call malice, real, actual ill will or spite. And for certain torts, you have to prove that actual bad motive existed.
So the big takeaway here is that it all depends. The importance of the mental state really hinges on which specific tort we're talking about. For some, like assault, your intent is everything. But then you have this whole other category called strict liability torts. And for those, think like cases involving defective products, you can be on the hook even if you were being super careful and had zero bad intent.
Okay, let's bring it all home. What have we learned? A tort is a civil wrong born from that idea of something twisted. You need those three things to prove it: a wrongful act, a violation of a legal right, and a remedy. It's not a crime, and it's not a breach of contract. And whether the person's intent matters, well, it depends. At its heart, tort law is really just society's mechanism for untwisting those wrongs.
Which leaves us with one last big question to chew on. We've seen that tort law is designed to be flexible, to evolve. So think about our world right now, with things like deepfakes, AI making decisions, all these new technologies creating brand new ways to harm people. What are the next wrongs that tort law is going to have to recognize? How is this incredibly old area of law going to keep twisting and turning to keep up?